On behalf of the appellant, Groven Farms.
May it please the court, Grant Van Amen on behalf of appellant Groven Farms.
Would you like to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes for rebuttal.
Please proceed.
This appeal is based on the incorrect finding of fact on the final page of the summary judgment order at record 1550. The trial court writes, Intercounty was to and did submit Groven's work, which was accepted by the owner in its pay applications prior to termination at Intercounty's unit prices. Some, but not much of that work was approved for payment by the owner. For that portion of approved work, the owner paid Intercounty, who paid Groven at its unit prices. The owner paid Intercounty, who paid Groven. That finding is the foundation of the judgment, and it is contradicted by Intercounty's own verified discovery responses, Intercounty's answers to interrogatories 11 and 12 at record.
And the order says what it says. The judgment says what it says. Are you saying a misstatement in a judgment in and of itself is enough for us to reverse?
Yes, I'm stating that the order is based on a finding of fact that the record completely contradicts.
Well, that may or may not be true, but my question is a little different than that. If there is something you have an issue with in a judgment, here a summary judgment, it has to be germane to the legal analysis. And as I read your initial brief, you say really there are two reasons it's germane. And one of those is the prompt payment laws. The second is the material breach concept. Is that the reason it's germane material here?
Yeah, Your Honor.
Well, let me first ask you about the prompt payment laws. That was not argued below, correct?
No, Your Honor, it was argued. It was argued. It's stated in our counterclaims. I have the citation.
So you argued it to the trial court at the summary judgment hearing?
At the motion for reconsideration, it was argued.
Was that the right time to raise an argument, counsel?
We believe it was.
So to follow up on Judge Eisenhower's very good question, did you argue it at the summary judgment hearing?
It was not argued at the summary judgment hearing.
So that's waived.
Okay.
Is it not? I mean, explain to me why it's not waived.
We believe that there was new facts that allowed us to argue at the motion for reconsideration. If it wasn't waived, then
that opens a box of perils that is a real problem under the rule.
Okay.
Well, I mean, new facts, it's too late. Is it not based on the rule?
Yeah, I'll cede the point. Even if it is too late, the argument fails because their argument is for post-termination payment. Groven was not seeking post-termination or payment for post-termination work. They were only seeking payment for pre-termination work.
Well, you told me a minute ago there were two reasons the purported factual misstatement in the judgment was germane. One was the prompt payment laws. That was not argued at the summary judgment hearing. The other basis was the material breach argument. Was that argued at the summary judgment hearing?
Yes, and the argument that Groven was seeking money for pre-termination work.
So the term material breach was actually advanced at the summary judgment hearing?
I believe so.
Well, isn't that that's important? That's important.
Yeah, and in our response to the summary judgment, we do argue that Groven was just seeking money for pre-termination work.
Well,
What about material breach, though? Are those sound like two different arguments? Did you
is it-
argue material
yeah,
breach?
Non-payment is the material breach. That's what the claims are based on.
So
Like,
now we're back to prompt payment?
Well, non-payment.
Okay.
Is the court, are you asking if non-payment is a material breach?
Well, I'm,
How did they not, sorry.
go ahead, please.
When were they required to pay? I mean, were they required to pay before termination? Don't you need your prompt payment argument for that? But at the time of termination,
Right.
what does the summary judgment evidence say what evidence says that they were required to pay your client before the termination occurred?
Well, yeah, the prompt payment, but
Now that's prompt payment, right?
sure.
But without prompt payment,
But the argument on summary judgment was about a provision in the subcontract, section 9.3, that is inapplicable to us, to Groven. It didn't make any sense that we
So-
were even arguing 9.3 because it's inapplicable to Groven's
so now
claims at all.
Now you're to the most interesting issue in your case, right? So now you've conceded prompt payment wasn't preserved. The materiality, material prior breach. It sounds like really what you're arguing is, hey, 9.3 doesn't apply.
Right.
That's really your argument,
Correct.
and that's really your only argument.
Correct.
And I think it's your most interesting argument.
Yeah. And,
But why does 9.3 not apply?
well, I don't see why it would apply because Groven's
I'm
only
reading it,
count.
counsel. Let's talk about the language. Why doesn't it apply here?
Well, there's a couple points that I can make. It doesn't apply because Groven was seeking money for pre-termination work. Section 9.3 is applicable when Intercounty is seeking money post-termination. Intercounty was paid the money that Groven is seeking in its counterclaim
And they
prior to termination.
Groven wanted that money after termination, right?
No, it was due to Groven under the prompt payment law within 10 days, which is prior to termination.
Counsel, you already conceded prompt payment wasn't preserved.
I don't think I conceded that. I think,
I thought you did, but that's fine.
Yeah.
I think that's the seedbed of everything that was never argued to the trial court.
Do you need prompt payment to prevail in this appeal? Do you need the prompt payment argument?
no, I don't think we need the prompt payment argument because we believe Section 9.3 was never applicable to our claims.
Where does it say that it's only help me out. Where's the language in 9.3 that you rely on to say, hey, look, 9.3 only applies to money that was the work that was done after termination, I guess?
So the
what work would
title
be-
of 9.3 is termination. And then there is no operative language that says it only applies to termination. So if we're taking what you're saying is true, Intercounty, based on the record, was paid money for Groven's work. And based on the record, they didn't pay that money to Groven. They kept it. So why would this language in 9.3 even apply to Groven's counterclaims?
Well, I mean, look, again, you didn't mention any language in the agreement. If we're interpreting 9.3, let's talk about the actual language. In the event of such termination, Intercounty's liability to subcontractor is limited to the extent of recovery on the subcontractor's behalf under the contract documents. Now,
And they did recover money
okay.
on behalf of Groven in their pay application number 3.
So it has nothing to do with when the work was done. Does it?
Well, we don't think that 9.3.
It doesn't have everything to do with whether Intercounty received money for subcontractors' work.
Sure, and they did. On the record, they very clearly received money for Groven's work.
Okay. Where's that argument in your initial brief?
Yeah, I think it's more clearly stated in the motion for reconsideration.
But we're not the trial court. Where is that argument? Hey, they received money For Groven's work, 9.3 requires them to pay the money they received for Groven's work to Groven.
Yeah, it's.
I didn't clearly see, and I was looking for it in your initial brief.
Are you asking for in the initial brief or the initial response to the summary judgment?
No, I'm asking you what you filed with us. The arguments you've made on appeal,
Yeah,
where is that argument
that.
in the initial brief?
Say that again, sorry.
That Intercounty received funds for subcontractors' work and therefore under 9.3 owes those funds to subcontractor.
I think that's the main basis in our brief, isn't it?
Counsel, the way I read your brief, prompt payment is the main basis.
Okay. Yeah, I don't think that's correct.
That's not how you intended it?
No.
Perhaps on your rebuttal, maybe you could clear that up for us. Where in your initial, so question number one, where in your initial brief do you argue Intercounty received funds for Groven's work, 9.3 requires them to pay it to Groven? Without being based on prompt payment, right? Mm-hmm. Or material breach.
Yeah, I think it goes back to section 9.3 just addressing the wrong question. 9.3, I mean, you read it. It allocates risk of what happened after termination, and Groven's counterclaims aren't about post-termination work or post-termination recovery. They're about the money that the commission had already paid Intercounty for Groven's work before termination.
What part of the language I actually read from 9.3, right? So we're dealing with contract interpretation. We should talk about the specific language in the contract. Mm-hmm. What language in 9.3 would you point to, regardless of what you argued in your initial brief for the moment? What's your argument based on the actual language of 9.3?
Well, they say that it's the title of 9.3 is termination, and then they're talking about to the extent of Intercounty's recovery. They did recover money on Groven's behalf prior to termination.
So you don't think I'm reading that provision incorrectly then? You agree with how I'm reading it?
Yeah, I do. And then the other argument being that the order produces an absurd and an inequitable result. On the trial court's construction, basically a general contractor can bill the owner for its subcontractor's work, collect the owner's payment, get terminated, and then keep the money. And the clauses that supposedly compels that result is one that the contractor drafted this contract in 9.3. Florida law.
That it's unfair. Your argument is that it violates 9.3, right? It's not. You don't need you're saying 9.3 requires them to pay money they received for Groven's work. We don't need to worry.
I think you can look at it that way. Yes.
But we don't need to worry about fairness. I mean, is fairness a basis for an award under contract?
No, but I think if you're allowing a contractor to get paid money, and that's supposed to be for the subcontractor, that's an absurd result if they're not paying the subcontractor that money that's due and owed to.
Absurd if the parties agreed to that? And I'm not sure the parties agreed to that here, but if they did.
No, I mean, if the parties agree to, hey, yeah, if we get terminated, we get to keep your money, but I don't think that's what happened here. And I want to just state that the money trail here from Intercounty's own verified interrogatory responses at record 2039 and in Intercounty's corporate rep deposition 1874 and 1875 follow that the commission paid Intercounty $235,000 and some change on November 18th, 2021, and $74,448.65 on January 20th, 2022. Termination wasn't until February 1st, 2022, and that money became due to Groven on January 30th, 2022.
Well, but then that's the prompt payment stuff, right?
Right. Intercounty paid Groven only twice, the $105,660 on October 18, 2021, and $11,740 in retainage on November 19, 2021. Intercounty admitted that it submitted Groven's pay applications 2 and 3 to the commission for $45,022.28 and $38,589.34. That's at record 1874 and 1875, and record 2039.
So they attempted to get paid,
Intercounty or Groven?
Intercounty.
Intercounty did get paid.
Well, what you just read there is that they submitted.
Yeah, they submitted it and they did get paid.
Okay.
And I'll cede my time for rebuttal.
On behalf of the appellee,
Good morning, Your Honor. Mike Piscatelli, my co-counsel Christina Strandell on behalf of Intercounty Engineering. May it please support. I was going to talk a little bit about the standard on summary judgment, but you didn't have questions about that. But
We're familiar with the standard on summary judgment, counsel. Was Intercounty paid for Groven's work?
Intercounty was paid. First, I don't think it's relevant. Second, Intercounty was paid for Groven's work that was approved by the owner. So it's not just a subject of, they submitted a pay app and we pass it along. We had different scope of work for the pay items. We have different unit prices and required approval by the owner. And we believe, we don't believe, Groven was paid for that work, which it accomplished and got approval by the owner at its own schedule of values.
Did Intercounty get paid for Groven's work, any amount of money that was not paid to Groven?
No. That was approved by the owner, yes.
That was what now?
Any work of Groven that was approved by the owner. Because the owner would not pay on behalf of Groven if they didn't approve.
Okay. I'm just trying to clarify. Did Intercounty receive payment for any of Groven's work that in any amount wasn't then eventually paid to Groven?
No.
Okay. If Intercounty had been paid for Groven's work, and 9.3 does 9.3 not say that would be turned over to Groven?
No, not at all.
All right, walk me through that.
Judge, this is a very specific contractual provision that applies to this exact situation. There are termination for convenience clauses all over the board, and they're different all the time, but this one is very specific to this situation. And this situation is that it controls the specific event that occurred, termination by the owner. It says, should the owner or construction manager terminate the prime contract or any part of the prime contract, which includes the subcontractor's work, and that occurred here, there's no argument about that. And it's not mandatory under that provision that the termination be the fault of the subcontractor, but here we know it was, because the jury ultimately ruled that Groven had breached the contract and awarded damages to Intercounty because of that breach. So we
Yeah, but that's not relevant to 9.3, right? Just all that matters is the owner terminates, right?
Okay. So if you keep talking through 9.3, in that situation, Intercounty is to notify the subcontractor in writing and the subcontractor shall also be terminated, we did that, and shall immediately stop work, and that happened. And then the critical section is, in the event of such termination, so this only kicks in when there's a termination. This isn't something that happens before termination. In the event of such termination, Intercounty Engineering Inc.'s liability to the subcontractor, Groven, is limited to the extent of Intercounty Engineering Inc.'s recovery on the subcontractor's behalf under the contract documents. That talks about what happens prospectively when there's a termination. That's what the parties agreed to, love it or leave it. That's what the parties agreed to. That's exactly the situation that happened.
So I hear what you're saying.
Okay.
So I'm not sure I agree with you. So what you're saying is Groven does $1 million, this is a hypothetical, okay. Groven does $1 million worth of work before termination. Intercounty doesn't get around to paying them yet, okay? Fair enough. Termination occurs. Groven stops working. Now at that point, what you're saying is, hey, look, whatever amount, the county, the owner, paid Intercounty after termination for Groven's work, that has to be turned over to Groven. Correct. But whatever amount of that $1 million they paid before termination, Intercounty gets to keep.
That's correct.
Okay? And you're saying I think I know what you'll say to this. I'm just curious. What specific words in 9.3 do you think lead to that result?
I'll answer your question. The words are, sorry. The words are, in the event of such termination, Intercounty's liability to the subcontractor is limited. Liability, not, that's something, at that point in time, liability to the subcontractor is limited to the extent of Intercounty's recovery on the subcontractor's behalf under the contract.
But it does not say post-termination recovery. It just says recovery.
Yeah, why isn't
But you got it, I'm sorry.
why isn't the payment before termination also a recovery?
Because it's fixing the liability at that point in time. At the time of the termination, our liability is limited to what we get
To whatever the recovery is, right? Yeah. So I guess the question becomes, why is recovery only post-termination? Why isn't, well, we collected $900,000 right the day before termination. Sorry, Groven, you're out of luck. Why is recovery not every dollar that is recovered, whether it be before termination or after?
I don't think that's a fair read of that statute. I think it's clearly intended to say what I'm suggesting it says, that it is the reset of the relationship at the time of termination, and it's reset that the liability is set to what recovery is made on behalf of Groven. It's not like we didn't try, by the way, but because of Groven's, I know this is getting away from your question, because of Groven's breach of the contract, the owner was unwilling to accept several suggestions we had, which would have put us back on the contract. We suggested putting Groven back on the contract with increased oversight. But because Groven breached the contract so badly, we were not able to do anything on their behalf or our behalf after termination.
I mean, look, 9.3 could very clearly say what you propose. I mean, it could say, liability is limited to the extent of Intercounty Engineering Inc.'s recovery post-termination on the subcontractor's behalf. It just doesn't say that. So, I mean, and I'm not trying to give you a hard time, counsel, but your answer to me was very, very conclusory, right? I asked, why does recovery only indicate post-termination recovery? And you said it clearly.
I'm sorry.
I just don't know that that's a strong answer.
Because recovery is a term of art. Recovery is something that occurs as a result of a situation. Here the situation was the termination. The question is, was there recovery as a result of the termination? That's why it starts out in the event of such termination.
Okay. So you feel like recovery is a term of art?
I do.
If it meant pre-termination and post-termination funds, payments, what would it say?
In the event of such termination, I'm answering your question, by the way.
Yes, yes. How would this language change?
In the event of such termination, Intercounty Inc.'s prospective liability to the subcontractor is limited.
So the key term to you is liability. It's all liability, before or after, upon termination.
But liability, yeah, but
I
liability
mean,
has to
that's
be-
what you're telling us.
I'm saying liability is the result of something. Here, that liability is the result of the effect of termination.
Why isn't it the result of Groven did work and you guys got paid for it? Isn't that liability?
A, didn't happen. B, no, that's not the agreement of the parties. I don't think you can read it that way in a realistic manner. If you look at the subcontract, there's different results. If it's a termination for convenience, the remedy is different. If it's a termination for cause, the remedy is different. If it's a termination for suspension by the owner, the remedy is different. If it's a termination by the owner, this is the remedy.
In fairness, counsel, we're throwing questions at you that weren't raised in the initial brief. I recognize that.
It wasn't a reply brief, by the way.
But your sort of your fallback position, and maybe your primary position is it kind of doesn't matter because your position is, hey, look, there was no evidence below to support the notion that Intercounty is holding funds that it received because of Groven's work, whether it be pre-termination or post. Is that your position?
My primary position, yes, that's.
Is that one of your positions?
But it's not my primary
Okay.
position. My primary position is 9.3 is clear, unambiguous. The parties treated it the way I'm saying, and the situation that occurred was in accord, was exactly what was anticipated by 9.3.
But you don't disagree with what Judge Eisnagel just asked you, meaning the fallback, if we don't agree with your view of 9.3, is this was just not preserved. This wasn't argued, correct?
Yeah. Yes, I didn't mean to be casual.
No, and you talk about it in your answer brief, that these are new arguments on appeal.
Yeah. So if you don't have any more questions, I'll conclude.
All right. Good.
So my conclusion is, as I've said, this is a situation where the party subcontract anticipated the exact situation that occurred, termination of the contract by the owner. The result of that act is spelled out. Neither Intercounty nor Groveland get any additional compensation unless there's a further recovery from the owner. That did not occur. The summary judgment gives effect to the parties' agreement, and it should be affirmed. Thank you, Judge.
Okay, I want to start out by going over the main point here, and one of the main points in the brief is that the trial court erred in granting summary judgment because there is a genuine issue of material fact here. They're saying we were paid, we're saying we weren't. That is,
Well, but we're going to go back to where I started. I get the argument, a genuine issue of material fact, it's in the rule. But it has to be tethered to something, some legal basis for there to be a genuine issue of material fact. And as I read your initial brief, prompt payment, material breach is the reason, is germane. I just don't see another argument. So is there another argument in your initial brief for why there's a genuine issue of material fact that the trial court missed here?
Are you saying in the brief? It's
In the initial brief.
in the initial brief. Yeah, I have a couple pages.
And specifically, where do you argue that 9.3 requires that Inter-County received funds for Groven's work before termination, and that 9.3 requires those funds to be paid to Groven?
I think the answer is on page 8 and 9.
Page 8 and 9?
Page 8 and 9 of,
Is that
the
is that in your statement of facts?
of the brief.
Oh, 8, all right, 8 and 9 is your summary of the argument.
Right, and then in section B, the material fact argument.
Could you give me a page number? Do you have a page number? If you don't, I'll find it, but.
Well, as I read B, it's prompt payment. B is all about prompt payment.
Right, that's part of it, and then the material factual disputes regarding the payment compliance as well.
That's this judge's point. The predicate for the material issues, purported issues, genuine issues of material fact is tethered to the prompt payment laws under B, correct?
I don't think it's only tethered to the prompt payment law. I think it's just non-payment in general, too.
Counsel, if you argued in the initial brief that Inter-County received funds for work that Groven did before termination, that they received those funds, that they didn't pay Groven, and that 9.3 requires them to pay it, if you made that argument, I'm asking you to tell me where.
Okay.
Give me a page number.
On page 26, it says the record evidence demonstrates that Inter-County did not pay Groven for pay applications number 2 and 3 totaling over $83,000, and whether these payments were made within the statutory timeframe is a material factual dispute.
I noticed that. That's not the context of the overall argument in that section, but that doesn't say that Inter-County actually got paid. It just says Inter-County didn't pay Groven.
Well, I think the record is that Inter-County was paid.
The record says a lot of things, counsel. Every record says a lot of things. I mean, we have an appellate rule that essentially, right, appellate principle, if you will. There's not in the rules. It's an appellate principle, longstanding, that you have to raise an argument in the initial brief for us to consider it.
Yeah, and I think it is raised in the initial brief under B2 whether the court's failing to consider the non-payment.
On page 26, the top of 26?
And 28.
And 28.
In number 2 in that argument. And that's my time we're asking the court to remand this for retrial.
All right, thank you. All right, that concludes our second oral argument of the morning. Counsel, for the third argument, if you would just wait 1 minute until counsel clears out before you come forward.
Thank you.